May I please, your Lordship?
Yes.
Lordship, I beg to mention item number 22. I am on behalf of amicus 23. 23. Amicus Kuri B. Chaudhary. Hearing item, Lordship. Some personal difficulty, matter may be adjourned, Lordship.
Why?
I am instructed over telephone that there is some difficulties, Lordship, on her part.
Then when does he want? Tomorrow?
Lordship, a week time.
Why a week? We think. Is I like this? He has to give sufficient reason.
Tomorrow, Lordship.
On the prayer for adjournment made on behalf of Mr. P. Chaudhary and the Michael Fury. List the matter tomorrow. The appellant has been convicted on the evidence of the mother-in-law of the appellant and mother of the deceased, who is PWA. You see, the thing is only because of that. Because the witness is the mother-in-law of the appellant and also the mother of the deceased.
Lordship, just now I am instructed. Lordship.
May I please, your Lordship? I beg to mention for listing of a criminal appeal. In the meantime, bail petition is pending, your Lordship,
When do you want?
as your convenience, your Lordship.
No, you are asking you are making the prayer.
Yes,
So today is it listed? It's not listed today. No?
not listed today.
When do you want?
This week.
Okay.
Yes, Mr. Lordship. I beg to mention for listing of Met Appeal Lordship. The matter was last listed on 14
When do you want? When do you
25.
want? When do you want?
21. 14 to 2025. Lordship, before vacation, any date, Lordship.
Give it a.
What's the place?
Mention.
Make a mention.
Oh, you read.
Yeah, please, Lordship. But with the consent from the other side, I beg to mention item number 15 for adjournment.
Why?
The senior is out of space on Lordship. I put the respondent number 2.
I know 15 is tied with 16. For 16. Who is the senior?
D goes.
He?
D goes.
Acha, for the respondent.
Yes, sir. Respondent number 2.
The adjournment prayer has been made on behalf of Mr. D. Goy. Miss D. Goy. Then counsel for the respondent number 2. Accordingly, in this matter, when in the next week.
Next.
Next week. Next week.
So 16, Lordship, 16 will be difficult.
Huh?
16 will be difficult, so it will be hard to stay.
No, 15 is connected with 16.
15.
Yes.
Huh?
Next week or is it next week?
Next week, we have some difficulties, Lordship, because we have some other matter in Itanagar.
Itanagar mein.
Yes, Lordship. Okay, after vacation. Keep your best luck.
Matter may be exam for the bail, Lordship.
Why?
But because the arguing counsel SG was some difficulty, could not issue after that.
Over phone, she has personal difficulty today.
I was also informed like that. Any that, Lordship.
On the prayer for adjournment made on behalf of
My name is B. Borgumai, Lordship.
B. Balpai, then counsel for the applicant appellant. It is not objected to by the other side. This is the matter on.
Lordship on next before vacation, Lordship. Anything.
The evidence shows that suggestions had been made that the victim had eloped with the applicant appellant.
16.
There was some elopement. In fact, it appears that the victim is the one who had instigated the appellant to elope. But she was very young. That's the problem.
May I please, your lordship? My lord, there is an IA under section 432 for suspension of execution of sentence, and my lord, in the meantime, I shall not receive my not feel to this. And since my lord 2016, he is in jail as well.
Only problem is this IA has not been registered. It's not registered. Filing number only is given.
I 1025.
Condemnation of delay petition already delay condemned, my lord.
Delays, that is all right.
Yes, my lord.
So anyway, we'll admit the appeal.
My lord.
Right, miss?
Please,
Where is your name?
Purnima Borua Bordole, my lord.
You're legally or what?
Yeah, my lord. Yes, my lord.
Miss Phoebe Bordeloi, legally counsel for the year. This is an appeal against the judgment dated 3/11/2016 by the Sessions Judge Kalkat in GR case number 242 of 2016, by which the appellant has been convicted under section 302 IP. That means the appeal or for the LCR. Miss A. Begum appears for the state. This is the matter after 4 weeks. Registry to registry IA and list about it.
Hello, blessed.
The TCL. I think we. All right, this is a jail appeal by which the appellant has been convicted under section 449 IPC, read with section 6 square. By judgment dated 25/6/2025, passed by the special judge POCSO, Lakhimpur, in special POCSO case number 107 of 2021, arising out of North Lakhimpur Police Station case number 1253 of 2020. Issue notice, returnable in 4 weeks. Ms. A. Begum accepts notice on behalf of the state. And registered to serve a soft copy of the appeal to the office of the PP for service of notice on the informant. The office of the PP shall thereafter send the same to the concerned police station. OC of the concerned police station for service of the same to the informant. This is the matter of the court. As I was said, admit the appeal, call for the PPR, no? Out here also same thing, but out here it is, wait, out here is it? This is a jail appeal against the judgment dated 13/12/2024, passed by the additional session judge Jorhan in special POCSO case number 80 of 2018, arising out of Mariani PS case number 212 of 2008, by which the appellant has been convicted under section 376 bracket 3 IP Issue notice returnable in 4 weeks. Ms. A. Begum accepts notice on behalf of the state. Appellant to take steps for service of notice. No, it's the same thing, huh? That's top copy, huh?
Second number. May I please, your lordship?
Acquittal.
Lordship, acquittal against acquittal.
Yeah, for whom?
I, on instructions, appear for respondent number 1 and 2, but it has
One
to be
and
admitted,
Lordship, today nobody's name has been reflected.
reflected in the cause list. But the
Anyway, we'll be part, waste of time otherwise.
lordship, that is.
You have filed Wakalatnama?
Yes. No, it's an legal appeal. I have already filed.
Okay.
I am there that there is a delay. Delay was.
Lordship, I have not filed, but in the condonation of delay, I had appeared in this. case.
Okay.
The delay was condoned, this is the criminal case.
Mr. U. Chaudhary, legal aid counsel, appears for the informant,
Informant, Lordship. Informant appellant.
who has put to challenge the judgment dated 16/3/2024, passed by the Section Judge Jorhat in Sessions Case number 191 bracket J-J bracket close slash 2018, by which the respondent has been acquitted. Respondents or what? Respondents
Two respondents.
acquitted.
They are the accused.
Under the charge of section 302 34, I think. Call for the LCR, TCR, and issue notice to the respondent. Ms. A. Begum appears for the state, while Mr.
V.A. Chaudhary,
V. Chowdhury appears for
respondent number 1 and 2.
file number 1 and 2. Are you filing a Wakalat or you have filed already?
Not filed, lordship, I have to take it, but I.
V. Chowdhury submits that he will file his Wakalat number within a week. This is the matter after 4 weeks.
Lordship, it will be not informant, it will be the victim aggrieved. She is not the,
The victim.
She is the wife.
Not
she is the wife, Lordship.
the
Informant.
informant.
No.
The wife of the deceased.
Yes,
Wife of the victim.
Object.
obliged.
Wait, please, your lordship.
Mr.
1-4.
Clear.
Of course, I send it.
Appear and counsel for the FC. Submit that the judgment dated 20/08/2024 passed by the additional session judge cum special judge POCSO, Morigaon, in POCSO case number 399 of 2023, arising out of Lahari Ghat PS case number 729 of 2021, by which the appellant has been convicted under section 6 of the POCSO Act, read with section 366 IPC. Should be set aside. Issue notice returnable in 5 weeks. 4 weeks, Ms. A. Begum appears for the state. The appellant shall serve a soft copy of the appeal to the office of the PP, who shall transmit the same to the OC of the concerned police station. The OC of the concerned police station shall thereafter serve a copy of the appeal to the respondent number 2. This is the matter after that.
Obliged.
Met, please.
Right, Mr.
A.L. Mandal.
Huh? Hey, Ahmed.
A.L. Mandal.
Your name.
6.
It's item number 7, I am appearing, Lordship. Yeah, no.
Heard Mr. A. Ahmed. Then a transfer for the appellant. Would submit that the judgment dated 12/11/24 passed by the section judge Dibrugarh in POCSO case number 22/2009, arising out of Hawang PS case number 84 of 2017, by which the appellant has been convicted under section 376 bracket 2 bracket I. IPC. Should be set up. Issue notice, returnable in 4 weeks, Ms. Ebega accepts this on behalf of the state.
For section 4 of POCSO is also.
POCSO is also
Four is
there.
there.
I read section 4 of the POCSO. No, but you tell me, the sentence has been done under what?
Sentence under not to get section 4.
Stop, So, whatever. That is section 12,
Four logic.
Yes,
Huh?
376 under
That is section 4.
sentence under 376.
Issue notice, returnable in 4 weeks, Ms. A become access notice from that state. Then that same thing, appellant has the soft copy, Then next. Who is the next?
I think
Miss
M. Malik.
Ms. M. Malik, learned counsel for the appellant. Submits that the judgment dated 21/7/2025 passed by the additional session judge cum special judge POCSO Morrigan in POCSO case number 43 of 2017, arising out of Mayong PS case number 164 by 2015, by which the appellant has been convicted under section 376 2I
Yes.
IPC, read with section 4.
No, my conviction was under section 376 only.
On the 376, to be satisfied. Issue notice returnable in 5 weeks. Miss A. Begum accepts notice on behalf of the state.
370.
Admit the appeal for the.
Only-
all that. No.
376, they will take such a.
Correct. No need. I don't think it's only for POCSO, no? Those those judgments are only for POCSO.
Yes.
Only for POCSO. Then this is the matter after 5 weeks. Then in the IA, right? Ms. A. Begum, additional PP is granted 5 weeks time to file written objection to the application under section 430. BNS. This is the matter of the file.
Obliged.
Right.
May I please, your lordship, this appeal referred to judgment dated 3/6/25, order dated 8/7/25.
Right, Mr.
D. Boraman.
Huh?
D. Boraman.
E. Bora, another for the appellant, who submits that the judgment dated 36/25 passed by the court of the additional session judge, some special judge POCSO, Kamrup M. Guwahati, in sessions case number 32 of 2024, arising out of Paltan Bazar PS case number 519 2020.
23.
By which the appellant has been convicted under section 6 of the POCSO Act, should be satisfied. If you notice, it's available in 5 weeks. Which may be accept notice on behalf of the state. And the appellant shall be accept that soft copy, okay, all that.
There is an I also.
In the I, right, Ms. A. Begum, additional. If he is granted 5 weeks time to file written objection to the application under section 430 BNS.
Deeply
This
over.
is the matter of the person.
May I please, your lordship?
Heard Mr.
Anuddin.
Then counsel for the appellant who submits that the impugned judgment dated 14/7/25 passed by the special judge Bongaigaon in special P case number 36 bracket BGN bracket close of 2021. Arising out of Bongaigaon case number 268 of 2021. By which the appellant has been convicted under section 6 of the POCSO Act. Admit the appeal, call for the CCR. Ms. A. Begum accept notice on that. Then the appellant shall serve a soft copy. This is a matter of the file. And in the I, right, Ms. A. Begum is granted 5 weeks time to file written objection. This is the application on the section. This is the matter of the file. There's so many POCSO matters, all POCSO.
Met please.
Mr.
A.L. Manzoor.
And Mandal, that's also for the appellant. Published at the impute judgment dated 22/5/25, passed by the additional session judge, cum special judge POCSO, Marigaon, in POCSO case number 50 of 23, arising out of Buragaon PS case number 170 of 2020, by which the appellant has been convicted under section 6 of the POCSO Act. Please set aside. Admit the appeal, call for the DPR, issue notice returnable in 5 weeks. Ms. A. Begum, accept notice on behalf of the state. Appellant shall fix. Then in the other one, I write, Ms. A. Begum is granted 5 weeks time to file an appeal.
It has come up as a part heard, my lord, even. No hearing.
I've been reading, that's why.
My lord, my lord. My lord, I'll be obliged if my lord take up, my lord. My lord, the issue is very limited, my lord. That whether from the date of, my lord, my appointment and joining, the benefit can be given or not, my lord. And the respected honorable single judge has denied, my lord, the said claim. On the ground, my lord, that as I have not put into challenge my regularization order, and my lord, as it is in the belated stage, both the claims cannot be, my lord, extended, my lord. That is the issue, my lord. Now, my lord, herein in our writ appeal, my lord, we have said that, my lord, as the date of appointment and joining has never been disputed, and I was continuing, and on the strength of date of that appointment and joining, my lord, my regularization have been effective.
Date of?
My lord, my date of appointment, my lord, may be pleased to find is at page 40, my lord. 12/7, 2000, my lord.
Page 14.
Page 40 is my initial date of appointment, 12th of July 2000, my lord.
Yes.
Then, my lord, on subsequent date at page 42 is my date of, my lord, joining, 17/7/2000. Then, my lord, there is a long, my lord, communication between the government. If my lord may be pleased to find is at page 44. Some development was there with reference to the subject cited above. Page 44, my lord.
Yes, yes.
My lord. This is a letter issued by the Under Secretary, Boruland Territorial Council, to the Director of Education, Boruland Territorial Council. Approval for conversion of the post and appointment of Sri Parkeswar Boro subject research with reference to the subject cited above. I am directed to say that the Boruland Territorial Council is pleased to approve the conversion of the post from mathematics to the Boro MIL, and Sri so-and-so Amguri Higher Secondary School is approved for regularization of his service against the vacant post as the appointed by the managing committee and as proposed by you by later under reference, my lord. So, my lord, and this is the adjustment of some subject teachers wherein, my lord, my name has also been reflected. My lord, may be pleased to find to the next page is at page 45. This is, my lord, a opinion by the Under Secretary that if any, my lord, adjustment is required to be done, that can be only go through the road, through the selection board, my lord. Therefore, you are requested to place the matter before the selection board for appointment of like adjustment against the vacant post. Now, my lord, as my regular.
Your name is not here.
But my lord, this, I was a subject teacher. It includes all those persons, my lord, wherein those persons are required to be adjusted. Yes, my lord, admittedly, my name is not there, my lord. So therefore, my lord, I approach before my lordships by filing a writ petition, my lord, at page 47, 48. My lord can skip the few, uh, Lord, may I read from the beginning? Lord, all these facts has been covered. If my lord, if I am not,
Yes, yes.
my lord.
Please.
The petitioner was appointed as a subject teacher in the subject logic and philosophy in the Boroma Higher Secondary School on an honorary basis as per the governing body resolution number 6 dated 3/3/2000, and which was communicated by the principal of the higher secondary school by the communication dated 12/7/2000. Since then, the petitioner has been rendering his service as a subject teacher in the subject logic and philosophy. Various process were initiated by giving regular appointment to the petitioner from time to time, as has been brought on record as per the annexure and annex to the writ petition, but none of the process had resulted in an order favoring the writ petitioner. Ultimately, the process culminated in the order dated 5/10/2016 of the Director of Secondary Education Assam, which is extracted below. So, my lord, this is an order by which hence the principal of Boroma Higher Secondary School is hereby directed to terminate Sri Basanta Burman honorary subject teacher and release him from service immediately. A reading of the order dated 5/10/2016 of the Director Secondary Education Assam shows that the order is based on another order passed by the Assam Information Commission Panjabari, so and so dated so and so. The order also records that the Assam Information Commission had observed that the petitioner is working as an honorary subject teacher of the logic and philosophy in the Boroma Higher Secondary School since 2000, but he could not produce any copy of the appointment letter issued by the authority. A further determining fact was arrived in the order of the director that the petitioner was not appointed by the government in a vacant sanction post after advertisement and selection, and therefore there cannot be any reason to pay regular salary. The director also take note of that the after provincialization of an institute, no honorary teachers can be appointed by the managing committee of the school or by the head of the institution. But what is intriguing in that director thereafter arrived at the conclusion that the Assam Information Commission had disposed of the claim of salary of the petitioner, and therefore the principal of the school was directed to terminate the service of the petitioner as an honorary subject teacher and release him from service immediately. If we strictly follow the provision of law relating to appointment of honorary teacher, the director would be right. But as already indicated, what is stringing is that the director does not take a decision on his own, but merely depicts the disposal of the matter by the Assam Information Commission regarding the payment of salary to the petitioner. Even if the Assam Information Commission had passed any such order, in our view, it would be an order without jurisdiction, inasmuch as the Assam Information Commission exercises its jurisdiction under the Right to Information Act, Act 2005, which pertains merely to either provide or refuse to provide any information that a citizen may seek for. The Assam Information Commission cannot have any jurisdiction to determine as to whether a teacher in a provincialized school, whether appointed on honorary basis or not, is entitled to receive any salary in the circumstances in which he may have been appointed. From the said point of view, we are unable to sustain the order of the Director of Secondary Education dated so and so and require the matter to be remanded back to the Director of Secondary Education for a fresh determination on the claim of the petitioner for payment of salary of the service he had rendered since the year 2000. We also take note of the aspect that although the director may be right in arriving at his conclusion that no honorary teachers can be appointed by the managing committee of a school or by the head of institution, but at the same time, the sequence of factors in the present case cannot go unnoticed. If the petitioner was appointed as an honorary teacher by the managing committee in a provincialized school, which was otherwise not permissible, and the petitioner was insisting for a salary to received by him, It was always open at the first instance itself for the respondent authorities to pass necessary order requiring the petitioner not to continue as an honorary teacher in the school. The communication dated 27/9/2000 from the in-charge inspector of school addressed to the director of secondary education shows that the petitioner had made an application for payment of salary as early as September 2000, and thereafter it was at a stage of processing the matter without any forcible, and in other words, the respondents were aware that the petitioner was appointed as an honorary teacher by the managing committee of the school, which may be dehorse the established procedure of law. But the very fact that the claim of the petitioner for salary was kept alive by the respondent authorities at the various stages, ultimately culminating in the rejection by the order dated 5/10/2016. It can also understood that the respondent in a collective manner had led the petitioner to alter his position in a manner that he continued with the honorary service with the expectation of receiving the salary. If he so continued and had foregone his other option of leaving the honorary service and look out for some other means of employment. Had the petitioner been informed of the requirement of leave the service at an early stage of his career, the petitioner could have taken appropriate steps to leave the service and look out for other source of employment instead of altering his position and continuing with the honorary service. Any person who may be required to alter his position to his determined by any act of the authorities would invite the principle of promissory staple, and along with it the principle of legitimate expectation would also follow. It is an established principle of law laid down by the Supreme Court in the Monads Path and Energy Limited versus so and so that the principle of legitimate expectations would hold good even if the act upon which the benefit of legitimate expectation is asked for would be dehorse any contrary to any established principle of law, including any statutory law. If the principle of legitimate expectation and promissory estoppel would be applicable in the case of the petitioner, the conclusion arrived at by the director that if it is impermissible to appoint on honorary basis in a provincialized school by the managing committee cannot be the only reason to reject the claim of the petitioner for salary. As we have already remanded the matter back for the appropriate decision, we also require the director to take note of the aforesaid aspect of the matter, that the principle of promissory estoppel and legitimate expectation would also be applicable in the claim of the petitioner. The director is directed
Yes, can continue.
My lord, the director is directed to pass his order taking into consideration the aforesaid aspect. However, we provide that the requirement of this order is peculiar to the facts and circumstances of the present case, and the same be not cited as precedent in any other case unless the facts and circumstances can be shown to be same. All other consequential orders pursuant to the order dated of the director also stand set aside. Writ petition allowed as indicated above. So, my lord, in the first round of litigation, my lord, this honorable court was pleased to, my lord, direct the director to consider the two aspects, my lord, as it has been noted, that is the legitimate expectation and, my lord, the promissory estoppel is required to be, my lord, considered in the speaking order, which was required to be considered afresh. Then, my lord, I submitted this order before the director, my lord, but the director was sitting silent. Then, my lord, ultimately, my lord, I had to prefer a contempt petition, my lord, and which ultimately the notice was issued, and basing on the notice, my lord, the notice order is at page 57, 58.
This is the director's decision.
Yes, my lord, the director's decision, my lord, may be pleased to find is at page 63, my lord.
Yes,
In accordance with the approval of the secondary education, may I read, my lord?
yes.
This is an order dated Kukrazhar, the 31st of March 2022. In accordance with the approval of the Secretary, Education Department BTC wide letter number dated so and in pursuance of the letter number dated 8/12/2021 of the Director of Secondary Education Assam, Kahilipura, Guwahati 19, and in compliance of the Honorable Guwahati High Court order dated passed in WPC number so. The services of Sri Basanta Burman, son of late Gopal Burman, so and so Baksa, is hereby regularized against the post of the postgraduate teacher in the logic and philosophy, converted from the post of postgraduate teacher in Assamese in the scale of pay of rupees so and so, and grade pay of rupees so and other allowances is admissible under the government rules, and posted at Boroma Higher Secondary School, Boroma, with retrospective effect from the date of issue of this. Sorry, my lord, it is prospective effect with the from the issue of the order, my lord. That this has the approval of the government by letter number dated so, and also has concurrence of the finance department communication vide number endorsement dated so and so, so and so.
Prospective effect.
Prospective effect, that's, my lord, from, it will run from the date of the order, my lord. That is the issue, my lord. That's why I have been denied. The,
So your order regularizing you says that it will take effect prospectively.
more prospectively, my lord.
Now you're asking for retrospective effect without challenging this order.
My lord, that is a technical issue, my lord.
No,
The tech-
sorry. Supreme Court has passed so many orders. That any order issued by the government
My lord.
seems to be valid unless it is set aside. Or
That is-
unless they withdraw.
No, my lord, that is an,
That's the long and short of it.
that is an issue, my lord.
When the order regularizing you
My lord.
says that it is with prospective effect,
Definitely.
you cannot say that I should be given retrospective effect.
My lord, my lord.
You should be given retrospective benefit without challenging this order. But more.
But my lord, the order passed in the judgment which I have relied on, my lord, which I have brought into my lordship's kind notice, it is very categorical and clear.
Challenge this order.
That is correct, my lord. That mistake, my lord, the petitioner, the appellant had committed, my lord, by not.
Now,
I have to
I
submit.
understand the problem, but the problem is that this order
My lord.
is very clear.
No, my lord, I have to submit fairly before my lord, my lord, because we are governed by the rule of the law, and the rule of the law is very clear, my lord. Now, only difficulty is that, my lord, there is a judgment. That judgment favors me, my lord, but those two consideration is totally missing in the speaking order. But until and unless I put into challenge, my lord, that is, my lord, may I pray, my lord, may I humbly pray, my lord, that my lord can close my writ appeal, my lord, with giving a liberty to the appellant, my
We
lord.
don't have to give a liberty. It is already there in the single judge's order.
Order, that is correct, my
Then
lord.
it's already there. Why should we put us? It's already there. Either you withdraw the writ,
My lord.
or we have to pass the necessary order.
That is only option left, my lord.
So it depends. Now, what do you want to do?
My lord, may I pray?
We cannot go against this order, and because we have not put it to challenge.
Single judge's order, my lord.
No. A single judge's order,
My lord.
which is also based upon this.
This order, my lord. My lord, I have also gone through, my lord. There is a mistake had been committed, my lord.
You did not challenge this order.
My lord, what has happened in this type of cases, my lord? When a person is, my lord, may kindly appreciate a man who is rendering his service honorary from the year 2000. Of late, my lord, when he got a regularization order, my lord, at least, my lord, he got something that on that day his expectation of getting salary, surviving his, feeding his family has arisen, my lord, from that day. And putting again challenging the very order, sometime maybe suicidal, my lord. That's the issue, my lord.
But what to do?
My lord, may I pray can be taken up on Wednesday, my lord. A small instruction.
There is nothing here. There is nothing.
Then my lord may.
Take it up at 2 if you want. You can talk to your.
Yes. At
You take it up at 2.
Yes, my lord.
Because it's very clear cut. This page 63 is
My lord.
the decisive
My lord.
document.
Oblige, my lord.
Please, your lordship, as per the last order,
Yes, and respondent number
it is
2.
report for the
Lordship, I may be given some time, maybe.
last two dates also has gone like this, 2020.
Appeared on the last occasion.
So paper book has been given to you.
Lordship, yes. The I is still thinking, can it be on the next week, at least for the notice?
Correct. Last chance.
Last chance, lordship.
Okay, right.
Paper book or no?
the matter has been adjourned on 2 consecutive dates to enable the prosecution to obtain instruction with regard to whether notice had been served upon the respondent number 2. Time is again being sought by the additional PP for the same reason. As a last chance, this is a matter on Monday,
Friday, I'll be
Friday.
this coming. Police station.
19th. DPO.
The juvenile matter, if you wanted to see, I have given those judgments on that day itself.
You see, we are reading some judgment. Now you see, when you talk of ossification, the first of all, then it's not foolproof. That is clear. Number two is in some of the judgments, the age is given. A particular age is given. Now, in your case, a range has been given. Age range has been given. Now, age range of 23 to 25 has been given. Now, if we take the mean age, I have seen in some judgments, Supreme Court has said that is not very satisfied with taking the mean age. It has basically taken the upper age limit. If it's 23, 25, it has taken the upper age limit of 25 and then given the benefit of 2 years and in some cases an additional 1 year as per the 2012 rules. So if it is but in some cases the benefit has been given for only 1 year. Now what to do? That is the problem. Now
Specific judgment, I have also not found this.
you see, but one thing, I have not seen a judgment where there is an age range given and the Supreme Court has considered the lower age range and then acted upon it by for giving that minus 2 years or minus 1 year. I have only seen where age range is given, then it takes the upper age limit and it acts upon the upper age limit.
Ultimately, this act is a beneficial act to the child.
Supreme Court is doing it, Mr. Kaushal, maybe, you see, we are bound by the Supreme Court. Now, if you can show me judgment where there is an age range given, say 20, 25, 27, and in the one case there was 30, 36. Now, if an age range is given, which that benefit of that minus plus 2 years is supposed to be given with regard to the lower age range or the higher age range?
That I have given one, that Durgaram case, Lordship.
Durgaram says?
Durgaram says, Lordship, if in this case, Durgaram's case, it was 19 to 20.
In my desk, there's an envelope with his kit. There's some judgment.
I have also brought one today.
Please. You see, the problem is that it's very confusing for us. Because, in some, the Supreme Court says only one year is to be given. You have
It says only 1 year.
rule says 1 year, the rule has now gone because of the Act of 2015. There is the 2012 rule is it still valid?
Has not been,
No, regarding that upper age limit, probably, Lordship, it is regarding victim's age, because that benefit of doubt has to be given to the accused. For that purpose, that upper age limit is there for determination of POCSO cases, Lordship.
Maybe, I don't know. We'll see.
But in against conviction, Durga.
year. Lordship, has your Lordship gone through 2017 to SCC 210?
Just a minute. Just Just
Ajit.
a minute, there's so many judgments.
Isum Diasan.
Which one, which party?
Mukkada and others was a state of
Acha,
UP.
I'm giving this for correction, this at that time. Where is it? Today's matter. Four zero eight, that's the one. Eh? Two thousand?
2017, 2 SCC, 210. No, today I have lordship.
Today.
No, maybe on the earlier occasions of submit, I don't remember your lordship.
It's not with
But
us.
today I have mailed it.
My, this is very small.
No, Mukkad up to.
It should be slightly, the font size should be big. I mean, this
SCR
microscope to read it.
0.
Madam, we need this thick glasses.
Sir, I have mailed my, I don't know how the printouts. My print is okay. Lordship, I can
This is good, huh? That's called discrimination.
It's SCC and I have mailed it, Lordship. I have not taken
Not
a hard
read it.
copy. Only one copy, I'm so sorry. So the marked it, finally I would do. An ossification taste cannot be the,
That is all right.
yes, my lord, Lordship, I can turn it, no?
This incident occurred in 2019. Correct? 2019. How old is he actually?
Even if you take lordship that 25 years, then also he will be juvenile lordship.
If you minus
Plus minus
2 years.
2 years.
But
There
if,
2
if,
years
if it
benefit
is
was given.
minus 1 year, then he becomes adult.
Okay, even then he will be juvenile lordship.
Even then he'll be juvenile.
Even
Oh,
then.
Probably.
still, let us clarify this issue
Clarify the
because
issue,
this case is becoming. Now you see, the 2012 rule provides that 1 year minus or plus can be. So, is this 2012 rules, has it been repealed or is it still there?
I think it's still there.
In my humble submission, lordship, that is now it is incorporated in the act itself,
No,
section
but
94.
But then the 94 does not talk about giving minus of
Yes,
1 year.
part is not there now.
That is
And,
not there.
Not there. And lordship, that is a 2016 model rule that is not given effect till now, lordship.
16,
Model
2016.
model rule is there.
But then model, if it's not given effect, then what?
That is
That
just,
model rule is going to repeal the 2012 rule.
no, lordship.
That
It is there, but it is not given effect. That is why I have pointed
what
out.
does 2016 model rule say? What does it say?
It is also silent regarding that part.
Then 2000, if 2012 rules is still still in existence, it's still valid.
But all the rules which were there in the 2012 or 2002 rules, the 2007 rules, those were incorporated in the act itself.
Maybe, but
All the more,
it's
all
still
the
there.
more.
Though it's incorporated, and 2012 rules has not been repealed.
Even if lordship takes that view, it is there, lordship. Then also it is in my humble submission.
If 5, then it becomes 24
Thank you, Rajendra.
in 2025. So he becomes 18. He becomes 18 then.
Lordship, that 6 years minus 19, 18 years. That from the date of occurrence, the incident occurred 4 months back. 4, 5 months back.
Yes.
When he was born.
So if exact age is what they are, lordship, that 1 year, that will be in addition, lordship. That is what I have given, lordship, that Durga Ram's case. It said it will be addition to plus minus 2 years. It, it cannot exclude that plus minus 2 years.
I think this Supreme Court has clarified. Giving plus minus, then giving another one by the under the rule. I don't think that was the intent. Where is that?
That
That around para 13 to 17. Okay.
paragraph 17, last 4 lines your lordship will get. After that plus minus 2 years, that to additional benefit of 1 year in terms of lowering his age by 1 year in terms of rule so and so, which should be bring him to 17 years, 2 months old. Therefore,
It says that and the applicant may be entitled to.
yes. Because it is
Maybe.
in borderline cases. If he is found to be, let's say, after plus minus 20 years, then that 1 year addition, that will not make any difference. So in that case, it is not applicable.
All guesswork.
Lordship, in 2023 judgment, this rule has been referred to. Pawan Kumar judgment. So it's
In which case?
Pawan Kumar versus State of UP. Last minus December, yeah, see. The benefit could be given to the child or child. Yes, in P. Yuva Prakash matter also, your lordship, I'm thankful to my learned friend. Criminal Appeal 1898 2023, it was also referred there. The rule is still in force, my lord. Let us have a hearing on this issue, your lordship, immediately after the vacation.
No. It takes too much time. We are hearing it now. We've been hearing it. Otherwise, while the thing is still fresh in our mind. You see, yeah, these are 20. You see, this Bhavan Kumar is 23, no doubt.
Yes.
But there is also a judgment in hmm, I think Karan Singh's judgment. Karan judgment. Karan versus state of MP. Karan versus state of MP. This 2023 5 SEC. For 504, it says secondary ossification test will only give a broad assessment of the age. It cannot give an exact age. There is also an element of margin of plus or minus 1 to 2 years. That is again 23 judgment. So out here also Supreme Court saying 1 to 2 years. So 2 years also. It does not limit itself to 1 year. That is the problem. So everywhere in some cases the Supreme Court says 1 year. In some cases it says 2 years or 1 to 2 years. So it means up to 2 years it can be done.
At the same hand, your lordship has to assess the gravity of the offense, even if lordship is a juvenile.
The gravity of the offense
a
is
bad
always
crime.
serious, madam. As long as it's rape on a minor, it is always a serious crime. It's not that one is less serious than the other. The seriousness is the same. The only issue is that when the Supreme Court has said that it will be 1 year in some cases, and in some cases it will be 1 to 2 years. Now, can we limit ourselves to just 1 year?
Another factor is the act committed by the accused person can be a person of a his conduct can be of a juvenile or an adult person, my lord.
That is
your
all right.
lordship has
That
to
is all
assess.
right. That is all right.
My lord.
Where you see the ossification test is done after 20 years or
My lord.
something, or 15 years or something. Here the case is that the incident occurred in 2019 and the ossification test was done in 25 July.
Yes.
And she was probably impregnated in April. DNA? No.
DNA profiling.
And on the other day, your lordship wanted to know whether the Jayamala's case is still holding the fifth.
Yes.
That I have given two other citations, lordship, where that Jayamala was relied. That is, one is of 2009 and one is of 2011.
Yes.
I have given two of those that Jayamala was relied on.
I have not found any clear-cut decision which says that it should be 1 year or it should be 1 and 2 years. In 2023 itself, Supreme Court has given various decisions in different cases, in some saying 1 year, in some saying 1 to 2 years. So then the only option before us is we give benefit towards the accused where it's possible. That is the settled law. If there are two views
One
available, one which is in favor of the accused should be given. Of course, I don't think it's correct where you give 2 years and then add another 1 year. 3 years, I think, is going beyond. I think that's not the correct meaning. But of course, even 2 years actually, there is no real. Maybe Supreme Court can do it under 142. Whether we can do it.
That law declared by
The rule provides only for 1 year.
yes.
Supreme Court is doing it for 2 years.
No, that 1 year is given to medical board, lordship. That if exact assessment is not done,
Okay.
then medical board can, in addition to that, 1 year can be given.
Okay. With the medical board.
Medical board. So that exercise can be done
By the medical board. We can do it for 2 years.
But 2 years and plus 1 year, that addition, that will be addition.
But
there are judgment in both the sides, my lord.
that is the problem.
Yes,
No?
fine.
So, like, you see, one thing he's correct. What he's saying is that the 1 year minus benefit that we can give is as per the rule given to the board.
Lordship, in his case, my lord, your lordship, subject to correction.
Yes.
Even if your lordship gives the benefit of only 1 year, he'll get the benefit. I think so. He'll get the benefit.
1 year he might not get. No.
If upper age is taken,
Then he will not get
25, then it will be borderline.
Then if we give 2 years, then he will come. He will get.
This model rule hasn't come into force, 16.
It is there, written there, but it has not been implemented yet, lordship.
How do you know? I mean, here it is coming.
It is written in the act, lordship, in the rules, but it has not been implemented yet. That what I have found till now.
Otherwise, how does the model rule help you?
And in model rule also, what I have found subject to correction, that all the procedures were taken in the act itself. So model rules only regarding that children's home, all those things. Lordship. That
There is
procedures are not,
there is nothing said about this one or two.
procedures are not there in the model. Probably that is what, probably because of that reason, maybe that was not referred to nowadays.
No, your date of birth was 2002.
Hmm?
Date of birth, 5/10/2002.
It's not for now.
Whose date of birth?
18 persons.
It's a date of birth now.
No, he was not there, but it was not there. It was like 18.
How do you say 5/10/2002, madam? If we that age, then he's a,
Subject to correction, my note says I'm not aware.
Probably that will
if
be.
he's 5/2002, he'll be very happy.
That will be victims.
Then
Maybe
2000. And victim also get to define school certificates regarding her age.
maybe this objection.
so why aren't we disposing of the entire case?
Yes.
But I leave up to your lordship. I think that case, lordship,
Oh, whether he's guilty or not.
bail, that part lordship may consider.
He's been in jail since?
Is the date of judgment, lordship?
Okay, so more than 3 years.
No, not more than 3 years, lordship.
Yes.
Yes, date of judgment is 23, 11/10/23.
10/23.
Earlier it was
2
190.
years, nearly 2 years. And earlier?
Earlier also 194 days. So 1 year,
194 days, 6 months.
6 months, 6.5.
So okay. So if you are found guilty, then you have got to go for another 6 months.
That remission part there will be there, those things will be there.
Very difficult. That's all. I think there's nothing else, no? Okay, right. Right. Mr. A. Ahmed, Leonard Council for the applicant, along with Ms. Bhuya, Leonard Fisher people. This is the IA or the appeal.
I leave it up to your lordship.
I think the because there's nothing to doubt that you are not the thing, you are not the
Perpetrator.
perpetrator. Only thing is with regard to the ossification.
In that case, lordship may dispose it of directing the board to pass appropriate order.
Maybe that.
Why appropriate order? Will pass for what? Lots ossification test is already there. Ossification test report is there. He's 23 to 25.
Yes.
So once 23 to 25 age range is there, what more order will they pass?
Regarding sentence for conviction,
The board.
yes.
Uh-huh.
Regarding that sentence.
Once
for
this
board-
declared a juvenile, this ordinary code.
Correct,
Then
correct.
not-
Then they have to go, yes. So we can go into that issue. So, okay.
That our court is in the judgment is they are regarding that motion yet is that.
Right, third Mr. Ahmed Land Council for the appellant applicant. I think is here, huh? Who is there? Who is there? Yes, Mr. Ali. We forgot you. Anything to say?
Regarding the age, what time is your tax of?
Age is
That part, my lord. So,
age according.
Comprehension part, that part will consider, my lord.
Yeah,
Here, there is comprehension part of 1 lakhs to pay the equity, that part only consider, my lord.
That to the DLSA will look into it. We are only interested in the money.
My lord.
That the DLSA will look into it. I think the court has passed an order, no?
Yes, ma'am.
Consider that aspect.
Yes, ma'am.
Then that's it.
That direction is given to the state to take.
Whatever.
Yes, the 15, but the 15 also the state of the.
Right. Third, Mr. A. Ahmed, then this Farawan, huh? Then
Last part, lordship, I see the order which I have given. He was granted bail directing the jail authorities to produce him before the juvenile board within 15 days and the,
then the 15 days.
and the, 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 and
Then wait, have para 1, 2, oh, okay. Para 1 to 4 is okay, huh? Next para. Para 5.
It's only about future course of action, how is
Yes.
the juvenile has to be
Yes,
treated.
yes.
The appellant has challenged the decision of the learned trial. On what ground? On what ground have you challenged besides age?
Besides that, victim's age is not conclusively proved because let's say the birth certificate, school certificates were given showing two different age, and medical report says she was major also.
On the ground that the appellant was a minor at the time of the incident. Further, the victim had produced two different
School certificates.
school certificates. Where is that?
That page 22, your lordship will find PW 8. Relevant portion, page 23. Material exhibit 1 and material exhibit 3 along with 4.
That is material exhibit -1, wherein the date of birth of the victim was mentioned as 5/10/2002. However, the material exhibit 2, which is the admission register of the school, showed that the victim had admitted herself in the school on 4/1/2011 in class 1, when she was 7 years old. What else?
Down below your third line, your lordship will get another material exhibit 3 was there, wherein her date of birth is different.
What is this? This counterfolio material?
Yes, the school issue,
Transfer certificate.
this date of birth, yes, lordship, as per certificate. The school register maintained by them was not.
Further, in the counterfoil, it won't be folio, I think counterfoil. In the counterfoil of material exhibit 3, which is the victim's school transfer certificate, the date of birth of the victim was shown as 4/5/2004. As such, when there was a dispute with regard to the age of the victim at the time of the incident, keeping in view the various documents that had been exhibited before the learned trial,
And doctors,
the date of birth of the victim was in favor of the appellant, would have to be taken, would have to be accepted by the. Further, the evidence of
page 18 PW 6.
yes,
Pay relevant portion, page 19, radiological examination, her age is showing to be major also.
further, in the evidence of PW6, who is the doctor who had examined the victim on 21/9/2019. The radiological examination of the victim showed her age to be approximately 20-22 years or above. And that the ultrasonography examination revealed a live fetus of 22 weeks, 2 days, plus dash minus plus bracket minus plus and then below minus 1 week of gestational age. The next para, the appearance counsel that something that there was no ground for in the learned trial court to have convicted the appellant under section 6 of the POCSO. And we are the above. Next para. On the other hand, the Ms. B. Buyan, the learned APP, submits that there is no infirmity with the age of the deceased, at the age of the victim at the time of the rape committed by the appellant on the victim, combined as much as the victim was below 18 years at the relevant point. Further, due to the rape, the victim has become pregnant and child has been born.
Yes.
And a child has now been born to the victim. So you are the father.
That lordship probably was a consent. If your lordship see page 61, 64
That the
statement.
physical characteristic may look the same. Anyway, right. He, however, submits that the issue with regard to the examination of the age of the appellant by way of an ossification test has already been conducted. And decision can be made in terms of the said judge. And the said ossification test report made by the medical board. Next. Huh? We have heard the land process first one. Huh? Then from here it will start. What is that, para? Eight. This will be 9. Yeah. So 9, 10. Okay, right. Para 18, huh? A perusal of the above judgment shows that don't say that. Yeah, 18, huh? 18. In the case of Karan versus State of MP, reported in 2023, 5 SCC 504. The Supreme Court has held that falsification test will only give a broad assessment of the age. Full stop. It cannot give an exact age. It also held that there is an element of margin of plus or minus 1 2 years. Full stop. Next paragraph. Just read what is that paragraph. No, we have heard the learn process for the parties. That is what paragraph. Cut that. Cut that paragraph. 7? Six. Then paragraph 8. How can it be? cut everything. Whatever I did, yeah, whatever I did, Amy, no, start from the very beginning. That is para. Okay, then next para, 6. What does it mean? Don't say the, okay, continue. That you put it here, huh? Para 18. By the way, how long? Just put it here on the 18 as not that part. 18. Okay. Next para, you're right. As can be seen from Rule 12 bracket 3 bracket B of the 2007 rules. The medical board can give reasons, can consider lowering the age of a child slash juvenile in conflict with law by a margin of 1 year. After recording reasons for the same. For determining the age. For determining the age. Rule 12 bracket 3 bracket B of the Juvenile Justice of the 2007 rule does not speak of the court giving the benefit of plus or minus 1 year of age benefit of age. The giving of the benefit of plus minus 1 year, plus minus 1 or 2 years of age to determine the age of a child can be given by the courts depending upon the facts and circumstances of each case. Next part. As can be seen from the fact of this case, As can be seen from, don't say that. As can be seen from the judgments of, as can be seen from the judgments of the Supreme Court. Plus minus one, with the no benefit of age of plus minus one can be given to a child at juvenile in conflict with law. In the present case, the ossification test held on held in July 2025 had given the age of the appellant as 23-25 years. When a age range has been given by a medical board on the basis of an ossification test, it becomes difficult for a trial court. It becomes difficult for a criminal court to decide as to whether the benefit of plus or minus 1 year of age should be given to the lower age range of 23 or the upper age range of 25. In the case of Mukarram, Mukarrab versus State of UP, reported in 2017 2 SCC 210. It has been held that it is well accepted that age determination using ossification test does not yield accurate and precise conclusions after the examinee crosses the age of 30 years. It also held that on the basis of the age of the accused appellants who were determined to be between the age of 35-40 years, giving a variation of 2 years in the upper age limit, that is very difficult. Here also, it has not accepted in this Mukarrab case. It has not accepted the ossification.
That was after 30 years, because at that point of time, he was more than 35, I think, as far I remember.
And this has been followed in 2023 also, 15. It been affirmed in 21, cited in 2 judgments. Very difficult.
And in probably Mukarrab's case or another case, also Supreme Court said it will be accurate if it is, let's say, between 20-25 years of age. So here he is 25, between 20-25 years of age.
What have I said? Besides an additional benefit of 1 year in terms of Rule 23, in terms of Rule 12 bracket 3 bracket B of the 2012 rule would bring the age of the appellant to 37. The Supreme Court in the above case, however, did not act upon the ossification report by holding that the age of the appellant therein, whose test had been done after they attained the age of 25 years, could not be said to be conclusive and could not be relied upon. As such, no, of course not. The Supreme Court thus held that an ossification test cannot be regarded. No, first of all, no. In the case of state of MP versus Anup Singh, 2015, 7 SEC 773, it was held that the ossification test is not the sole criteria for age determination. No, no, and it cannot be regarded as conclusive when it comes to ascertaining the age of a person. More so when the persons have crossed the age of 30 years. In the present case, the appellant has apparently not crossed the age of 30 years when the date of when the ossification test was held. Inasmuch as his date of birth
Is not there.
no, Mustafa, that's all. That is Mustafa. Next para. In the case of Darga Ram, alias Gunga, Gunga, Supra, the Supreme Court has held that when the Supreme Court was considering the ossification test, wherein the medical board had estimated the age of the appellant in the range of 30 to 36 years, as on the date of the medical examination. The Supreme Court held that when there has been, no, has held that age determination can vary plus minus 2 years. But the medical board had spread the age of the appellant over a period of 6 years. That is 30 to 36 years. And taken a mean to fix the age at 33 years. The Supreme Court held that they were not sure whether the taking of a mean age in respect of the age range from 30 to 36 years would be the correct way of estimating the age of the appellant. It held that even if the age of the appellant was determined by the upper extremity limit, that is 36 years, the same would be subject to variation of plus minus 2 years, meaning thereby that he could be 34 years as on the date of examination. Para 17 of the judgment of the Supreme Court in Darga Ramha, alias Gunga, is reproduced here in Viras. Next. What can be gathered from the various decisions of the Supreme Court is the fact that there can be no conclusive proof of age on the basis of an authentication test. It has been held by the Supreme Court that there can be a variation of the age by plus minus 1 to 2 years of an accused. It has though nothing has been stated in the act or the rules that courts can vary the age of an accused by plus minus 1 to 2 years after having an ossification test conducted on it. Besides the above, variation that can be done by the court as held by the Supreme Court. The medical board who conducts an ossification test can also give a variation of plus minus 1 year at the time of making its report on the ossification test, provided it gives reasons for the same in writing. Good stuff. Next part. A reading of the judgments of the Supreme Court would show that when there has been a age given of given on the given on a person on whom ossification test has been held, and the age range has been made like in the present case, or in cases where the age range is spread over 5-6 years, comma, the Supreme Court has not felt comfortable with the fixing of a mean age, MEAN, mean. It is seen that the Supreme Court has usually acted on the upper age limit given by the board, by medical board, and applied the benefit of variation of plus minus 1 to 2 years on the upper age. Correct? On the upper age limit it has acted.
Some government says, Lordship, that lower age, some says.
Show me that, no?
That I have.
So you see, because it becomes very difficult now. So it has said that mean age they're not comfortable with. I have got the ones where the upper age limit has been acted upon. Show me where the lower age limit, because we are making the law now. It might affect you in
That
the
is what
future.
the Jayamala case, Lordship, which I have given and which is relied on in 2009 judgment also. SCC 2009.
2009.
Yes, volume 6.
2009. 2009, yes.
Paragraph 13, Lordship.
That's it.
Two years.
No,
on
no, that is
either-
all right.
2 years on either side.
I am not on that. That is all right. That is when one age is given. When there are two ages given, say 24 to 30,
No,
23 to 25.
that's it.
Now that plus minus is to be acted upon 25 or 23.
In Jayamala's case, it was Lordship that 2 age was given, Lordship, that in between was given.
That is what, no, now Supreme Court has said in this case that the mean age,
Meaning.
they're not comfortable with the mean age.
Okay.
Very
But that,
difficult now.
but again, that the act is of beneficial nature, so that the
But Joymala case with regard to the rules, no?
rules.
Then with regard to the rules, is it with
No,
regard to the
that was, Lordship, at that point of time, that 1986 Act was there. Earlier.
86 Act? In the 86 Act, was there a plus minus variation allowed?
No, that point of time, 16 years age was there.
16 years.
16 years. So here it
That
was
is
given
what
17
this
to 19 years.
has come about.
17 to 19 years it was given.
Huh?
So 17 to 19 years. Here in this case.
In return.
Jayamala's case.
17, 19 by whom?
In Jayamala's case, the person was 17 to 19 years.
And 17 was taken into account.
Yes, that's it. That paragraph 8, Lordship, see. 8 and 9.
No, out here there was no, there was a test or what?
Yes,
Was there any association test?
yes, Lordship, may I kindly see page, paragraph 8.
There.
The doctor opined that he was between 18 to 19 years.
Ah. So he was between 18 to 19 years. So once you give 2 years, he comes 17. So upper age limit.
Then at that point of time, it was 16.
16.
16.
So if you are 17, he becomes
17, then
15.
2 years, then he was.
But that is not what it has been said.
Detained was as a detained the report after going. But where it is written that 2 years on either side.
2 years on either side for which age?
That the between also it is 18 to 19. So 18 plus minus 2 and 19 plus minus 2.
Plus minus 2 would be 16.
Yes, 16 to 21.
Cannot be. That is not the, cannot. You cannot widen the age range so wide.
On either side, if we also be on either side, that my humble submission is that lower side has to be taken, because if it is taken as in my case, if it is taken as 23 years, then he will as it is a beneficial legislation, that therefore also that benefit has to be given on lower side, considering the lower side.
If in your case we take the higher side also, still you come lower.
Still it will be lower, but
For future.
for
Only problem is this dargah. This is your case only, dargah.
this is the similar view expressed by your lordship just now, that in broader sense, if we take, then lordship that it has to be that lower side. But in that case also, in Durgaram's case, he was.
Actually, my view is practically, my personal view is that the mean age should be taken. That will be the most fair. If they say a person is between 22 and 28 years, supposing, then which should we take? 22 to be the age, and do we give -2, it becomes 20. Or should we give we should take 28. That is what I say mean age should be given, but then that's
In
not
that case,
comfortable with
the
that.
Delhi High Court judgment I have given, in that case 30 to 40 was there, and Delhi High Court taken the view of that 30 will be applicable. But Delhi High Court division bench judgment.
No, I am all right with Delhi High Court. I am all right with that. Problem is Supreme Court out here.
That's it.
In para 17, Dargaram.
In that case, lordship, it was observed that even if you take that upper age limit, then also you will be lordship a juvenile. That view was there. So subject to correction, which is what I have understood. That is what I have also submitted, that even if you take the 25 upper age limit in my case, then also he will be juvenile. That was my submission before.
Okay, we'll decide that, huh?
Lordship.
Hearing concluded, judgment reserved. Actually,
and some of the cases I have found that where lordship that in POCSO cases, when victim's age was determined, that benefit, then also upper age limit was taken, because the benefit of doubt has to be given to accused.
okay.
In that case, that upper age limit was taken.
So if out here if we hold that he is a minor, then we have got to refer this to the
Just
The-
both.
the-
juvenile.
JJB. To the JJB.
So,
To give appropriate sentence. Keeping in mind the how long has he been in jail?
more than 2 years, 6
No, let us see. Judgment was passed.
judgment was passed on
No.
11/10/2023.
11 judgment was passed on 11/10.
Then
When was he put in jail?
he was put in jail on the date of judgment.
And then prior to that, he was in jail in the
From 3/10/2019 to 11/5/2020.
3/10
2019
19 to
and released on 11/5/2020.
11/5/2020.
20. 194 days prior to judgment.
194. Okay.
Obliged.
We are more on the how to calculate the plus minus part. That is,
That I have also searched, but a specific judgment I have not found.
you just send it to my others not required. This off, huh? Good.
Obliged.
Lordship, I pray for little of accommodation. This matter to be taken up any other day, the next one.
Lordship, today it was fixed in the point of consideration of charge as charge has been framed on a wrong section and admittedly charge has been framed under
Correct.
section 22.
Correct. It have
21.
been framed under 22.
Yes, admittedly.
Has to go, madam. There's nothing here.
Lordship may be taken up on some other day, my.
Otherwise, the matter was about to remand back to the learned child.
Ah,
In that even of the matter whether under Lordship may take into account 464 also. Error in framing charge, whether it has caused injustice to the.
naturally, it's like this.
Whether that.
It is like this. It is like this. This she has been convicted under 302. But she should have been convicted under 304. She should have been convicted under 366. Heroin, she has been convicted under 21C. 21C is basically heroin, nothing else. But what was seized
Yeah, but.
was amphetamine. Amphetamines has to be charged and convicted under 22.
I don't know, Thursday or Friday, any day. Actually, it was my mistake. I have not informed my panel lawyers about this matter. I informed them last week, but yesterday not. I know.
Okay, we'll fix it on Thursday.
Thursday or Friday? On Friday.
On Friday, we're fixing too much. we need also, we are going to
On
split.
Thursday.
Okay, right. Yes, madam.
Lordship, there is three accused
Ah.
in this judgment. I have also filed one jail appeal, Lordship, for the accused number 1. That matter may be tagged with
In this case,
Lordship.
all of you were amphetamines
Lordship,
and all of you are under 21C.
Lordship.
I think that inspector, whoever it is, I think he's in cahoots with this person. How can you do such a or what? It is the court which has the framing of charge. How can you do that? It is so obvious. Heroin is always 21. Nothing else comes in 21. Who is this judge?
Framing, then convicted.
Well, I can understand if they make a mistake during the judgment. But at the time of framing of charge, why is the prosecutor didn't say anything? No one said anything. This is a commercial quantity. Very rich. He'll be very rich also. Naturally. So I do not know what's happening. How many accused?
There are 3 accused.
Three.
One of them is acquitted, other 2 have been convicted.
That it was seized from where? From a vehicle?
No, seized from the personal body search.
Body search.
Yes, section 50 comes into the picture, Lordship, and there is a non-compliance of section 50.
Who was acquitted?
The other one who has been apprehended by 67 statement, NDPS 67 statement. And he has been acquitted. And the other 2 on the spot, apprehended on the spot, has been convicted.
You are Muhammad Ali Muddin,
Yes.
and you are
Number one, Lordship.
Mete.
Mete, Lordship.
Hey, my son Mete. How come? No case, huh? And this went on for this case went on for so long.
Yes.
No.
3.7 years of custody as of today.
3.7 years of custody. Unbelievable. I think you should take some action against your officials. Let us see the. Just let me see something.
Yes,
21C. Give me the indicators. Right. They're right on the prayer of Miss B. Buyan, Leonard APP. This is the matter on Thursday. The matter relates to the appellant being convicted under section 21C, even though the seized contraband was amphetamines and methamphetamine. Charge had been framed under section 21C, 23C, 27A, capital A, yeah, and 29. And convicted under 21C only, no? Operation successful. Huh? How did you all do it? How did you all do it? How did you all manage?
Lordship, that is a matter of question that is to be heard, Lordship. Because there are about 20.
No, how did you manage having the case registered under 21C? Unbelievable, really unbelievable. I can understand small quantity here. There is big quantity. And I mean, everywhere, even the court, no idea about NDPS. 21C doesn't come into the picture at all. It's like heroin being caught, being seized and recovered, and you being charged under 20B2C, 20B2B for ganja. How can you do it? Thursday.
My matter may be tagged, Lordship.
Yeah, matter. You file a mention memo, madam. How can we just order this like this?
Lordship, yes.
Is it listed today? Yeah, madam.
No, Lordship.
Then
Seminar.
you know the mention memo. You give a submit a mention memo tomorrow.
Lordship.
Madam Buyan, I think we'll have to think of,
Lordship.
we'll have to sit it back and have a fresh thing. Because there's no case. No case at all.
Lordship, we need to file our objection, my lord, in this matter.
And in the meantime, my lord, directed the registry to prepare the paperwork, my lord, 20 years conviction.
Section 4.
Yes.
Section 4. Okay.
Yes.
Right, Mr. A. Ahmed appears for the applicant. Ms. B. Buyan is granted
2 weeks.
2 weeks time to file written objection. As then in the main appeal, right? As TCR has arrived, registry to prepare the paperwork. List the matter.
After prepare the paper.
List the matter for it.
Yes.
Learned friend appears for victim.
Victim is.
Yeah, budget for the victim.
Azharuddin to.
Yes.
Okay. Objection from class. 18 minor report is awaited from the concerned OC. We have written to them. Short date be given.
Okay, right. What about your written objection? That has been
Already filed.
They file already objection on file.
what about on the IA?
I but the notice has been issued to the.
We'll hear without the RP. What is there? What have you got to say?
Regarding I, my lord.
Yes.
I, my lord, what has happened in this case, my lord? There are 2, 3 versions are there, my lord, regarding it is under section 6, my lord.
Yes.
But at best, it can be a case under section 8 or 10, my lord.
And the second petition was permissible.
Lordship, in this matter, we have filed our objection only day for yesterday and Friday. It is not on record. It come. Maybe taken up some other day.
Yes, my lord.
Copies is served.
Ms. P. Buyan, Leonard,
Senior friend.
addition PP submit that objection. The application has been filed. If they receive to pay the same on record. Then in the main appeal, you write the registries to make the paper book. This is the matter. After 4 weeks. 31.
Need be pleases your lordship. Here IA has been filed, your lordship, seeking medical ground, your lordship, to grant bail, your lordship. Because your lordship, the petitioner, the applicant, your lordship, has suffering, your lordship, prolonged medical issues, your lordship. On the earlier occasion, your lordship, he was admitted for diabetic treatment, and thereafter, your lordship, he was admitted again in page 6, your lordship, paragraph 7, I have stated. I would like to read it. That the accused, that is appellant presently is in Jorhat Medical College Hospital, Jorhat, where he got admitted on dated 22/8/2025 at 9 p.m. in the presence of jail authority. The accused, that is appellant, is not well and his health is weakening day by day by suffering from diarrhea. The accused, that is applicant, family members were informed on the very next date, that is on 23/8/2025 at morning 9 a.m. After getting information of the accused applicant, your lordship, unwell, family members used to visit the hospital. As soon as the arrival of family members seen by the doctors, the prescription were handed over to the family members. It was not given any free treatment, your lordship. As soon as they have seen the family members, the doctors give prescription handed over to the family members, giving the medicines and other necessary things to brought your lordship. And thereafter, your lordship, in paragraph 8, your lordship, all the medical receipt prescriptions were annexed, your lordship. That is a annexure 1, which I already annexed it.
All your medical documents, madam, are of August.
And your lordship, on dated, your lordship, he was handcuffed, your lordship, in 15 paragraph, that is 10, page 10, paragraph 15. Your lordship, I have stated that he has been prolonged diabetic patient and his sugar level has gone by 500 plus and has no attendant was there in the Jorhat Medical College and Hospital, and he was living all alone with handcuffed attached to its bed, as he was found to be very difficult going to bathroom for toilet purposes. He was left alone by attendants. Therefore, the accused applicant on dated 1/9/2025, he again gone back to the jail, your lordship, custody. So, your lordship, for his, your lordship, welfare, your lordship, and your lordship, to give proper attendant, your lordship, with medicines and care, your lordship, kindly grant him bail, your lordship. Since the appeal has already been admitted, your lordship, a short date may given, your lordship. All steps has been completed.
We
And
can,
there are
we can
me-
decide the appeal.
Yes, your lordship.
And
Any date may be given, your lordship.
when you
But
we
your
can-
lordship, paper book has already, I have seen in the records, paper book is available in the records, which they have not produced, not given to me, your
I'll give
lordship.
to you. What about you, madam? You have been given paper book?
Yes, I have received. I have not received yet, your lordship.
PP has been served. Give it to her.
Lordship, I am appearing for response to Lordship. I have filed my Wukalama, Lordship.
Have you been given paper book? No.
Lordship, I have filed my Wukalama. My name has been, actually earlier I filed my Wukalama criminal appeal, that J I have not put. So my name not reflected, Lordship. I corrected. No, I got the,
fine.
Have you got the paper book?
no, Lordship.
Yes, madam, what to do?
Maybe taken up for final hearing. Yes, sir.
When?
Short date may be given, your lordship,
Anytime you're ready. Next week?
next week.
Right. Miss P. Das, Learned Legal Aid Council, is present along with Miss B. Boyan, additional PP, and Mr.
S. Sutadhar, Lordship, R2.
S. Sutadhar, Learned Council for the appointment. Registry to provide a copy of the memo of the paper book to Mr. S. Sutadhar, Learned Council for the appointment. This is the matter for hearing on. Then you are next week.
I'm deeply obliged.
A copy of the paper book has been provided to Miss Pida in the court today.
Deeply obliged.
Right.
Lordship, in this case, Lordship, paper book already prepared, Lordship. And, Lordship, but, paper book was not furnished to us, Lordship,
People not furnished.
not yet furnished. Lordship.
PP has received.
Yes, sir.
Okay, right, your turn. Your name is not here.
Are you sure, Lordship?
Item 26.
26.
No, your name is not here. That is there. Which fellow is there? Okay, Mr. Ayush Chowdhury, the for the appellant is given a copy of the book in the court. Then we list it for hearing.
I is there, Lordship.
You want to say, yeah, okay, see, what do you want to say about the I?
Lordship may fix any date, Lordship.
We'll fix the thing, why I?
Lordship, then Lordship fix
List the matter for hearing
date may be fixed.
After vacation, Lordship.
after the.
After vacation, any date, Lordship.
Mhm.
Any date after vacation,
Give it.
date may be fixed. Deep development.
Let us wait. The paper book has not been prepared, I think. Right. As the paper book has not been prepared, this is the matter. After the much of it. Maybe. So we take it up at 2.
At two, Lordship.
Lots. And then it's like- Dismissed.
Fix that to item 25.
Milord can dispose of Milord.
Okay. You're right. Heard. Mr. A.R. Bhuyan, then counsel for the appellant. Also heard. Miss H. Barwa. On behalf of Mr. P. Nayak, then counsel for the BTC. This appeal has put to challenge the order dated, the impugned order dated 3/8/26, passed in WPC 3930 of 2020, by which the appellant's prayer for being granted a regular salary from now for his service period as an honorary teacher with effect from
15/9/2000, Milord, date of joining.
fair of 15.
Milord, may be pleased to find my joining. Page 42, Milord, 17/7/2000.
Page 17, page.
Page 42, Milord, is my joining report as an honorary, Milord.
Where was that? With effect from, date is not here, with effect from,
Milord, the date, my lord, may be pleased to find, is that in the
let's just say on the basis of the order dated 12/7/2000
my
till the regularization of his service. Is it? No, till the regularization of till the regularization of the service of the appellate by 31/3/2020 has been dismissed.
my
The learned single judge, by the impugned order dated 3/23, had held that as the appellant had not put to challenge his regularization order, whereas the appellant's regularization along with his scale of pay and grade pay was be with prospective effect from the date of issue of the regularization order. Wherever I think this is. No, just how did the sentence start? No, he's not said that. Sorry. He's not said that. Yes. He has said that. He's not said that. No. What have I said? Just don't think that had held
Para
that the appellant having accepted the terms and conditions of his appointment order dated 12/7/2000 as an honorary teacher, as an honorary subject teacher, he could not retract from the same without challenging his appointment order dated 12/7/2000. Further, the writ petition had been filed only on 30/6/2023, that is after 23 years of service as an honorary teacher, claiming arrears salary from 12/7/2000 till the date of his regularization in service. We have now next Miss Renso, Leonard Counsel for the respondent, on the other hand, submits that there is no infirmity with the decision of the learned senior judge, and the same has to be upheld. As can be seen from the records, the appellant appointed as a subject teacher for logic and philosophy on an honorary basis by the principal of Barama Higher Secondary School, Barama, the contents of which are reproduced therein below as follows. Page 40. Next paragraph. The regularization of the petitioner's service had been done while order dated 31/3/2022, wherein it has been specifically stated that his regularization along with the scale of pay and grade pay and other allowances would be with prospective effect from the date of issue of the order dated 31/3/2020. Next paragraph. The impugned the regularization order dated 31/3/2020 is reproduced herein below as follows. 362. Next paragraph. The order dated 31/3/22 giving regularization to the petitioner's service along with his scale of pay and allowances has been made only with prospective effect from 31/3/2020. No challenge to the said order dated 31/3/22 has been made by the petitioner till on account of the fact that the order dated 31/3/2022 has attained finality as on date, without any challenge being made to the same by the appellant. We do not find any grounds to interfere with the impugned judgment of the learned panel.
Single judgment.
Well, not single judgment. The appeal is accordingly dismissed.
Lord, may I pray for a liberty, my lord, if he is advised so many.
You can always do it. You can always do it.
Oblige.
May I please, your lords? This is your lordship, a conviction under POCSO, your lordship.